मग जास्त तर काही करू नको. आवाज येते भांड्यांचा. नहीं लक्ष्मी लौटकर आली. नहीं मैं सोचने वाला था कि आप जल्दी आएंगे तो अच्छा है. नहीं नहीं
लक्ष्मी ये दोनों में से
चालू ही वीडियो बोलो.
Assalamu alaikum and good morning to all. On behalf of Anjuman-I-Islam Kalsekar Technical Campus, I, Dr. SAI Bellary, Associate Professor and Controller CIRDPI, welcome to all of you, the participants and faculties and other participants for webinar on intellectual property right and IP management for startup. As a tradition of Anjuman-I-Islam, I request Professor Fawaz Parker sir to recite a few verses of Holy Quran.
Yeah. Good morning. Am I audible, sir?
Yes, yes, you are audible.
Okay, sir. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. إنا أنزلناه في ليلة القدر وما أدراك ما ليلة القدر ليلة القدر خير من 1000 شهر تنزل الملائكة والروح فيها بإذن ربهم من كل أمر سلام هي حتى مطلع الفجر. The meaning of these verses. Indeed, we have sent the Quran down during the night of the decree. And what can make you know what is the night of decree? The night of decree is better than 1,000 months. The angels and the spirit descend therein by the permission of their Lord for every matter. Peace it is until the emergence of dawn. Sadaqallahu al-Azim. Over to you, sir.
Thank you, Professor Fawaz Parkar sir, for reciting the verses from Holy Quran. Now I will introduce the speaker for today's webinar on intellectual property right and IP management for startup. That is our Mr. Gajanan Sadekar sir. Mr. Gajanan Sadekar sir is a mechanical engineer with his post-graduation from IIT Bombay in 1978. He was adjunct faculty at VJTI for academic year 2017 and 18 and has worked as a visiting faculty at various institutes. He worked as a vice president at L&T Mumbai. He has vast experience of 40 years. He has obtained 5 patents for L&T. He is the member of various professional bodies. He has published more than 20 papers in national and international journals. With this brief introduction, now I request Mr. Gajanan Sadekar sir to start the session. It is over to you, sir.
Okay, thank you. Let me share first. Are you able to see? No? Are you able to see?
Yes, sir. Yes, sir. Proceed, sir.
Okay. Good morning to all, and thank you for giving me opportunity to share my thoughts with you on IPR. It's a really, I'm happy that you are taking this type of initiatives, because it's very important to know a little bit about intellectual property rights, as well as because as an academia, you may like to develop some of the IPRs in future, and this may start as the little bit to give you an idea of how one should go about it. So what I'm actually going to do, we'll have something like, say, around 45 minutes to 50 minutes I'll try to cover, because it's very difficult to cover in 1 hour everything. But I'll have some keywords for you, and we'll talk on something which is a little bit more detailed, something we'll just touch upon, but to get an overall idea of the intellectual property rights. That's what we are going to do in next 50 minutes. Okay. And what we can do is we can have question answer session, maybe 5-10 minutes, because we have to finish before 12:30 as required by you. So what we can do is we can send your questions if there are any we are not able to take up today, then you can send it to professor and he can forward to me, and I'll make sure that I'll reply the same. Okay. So with this background, let us start. Yeah. So overall objective of this particular thing is like you also have written what are your objective. You want to know about title itself is giving the objective. So I'll introduce the concept of the intellectual property rights, And there's a role in technology transfer, because basically startups will be developing some technologies. And if you want to transfer those technologies to the big companies or something like that, what type of licensing can be done? We'll little bit talk about that. So first of all, let us, what I'll talk in topics will be, what is this protection is all about? When you say IPR, what is the protection for the IPR? Different kinds of IPRs. Are you able to hear? Are you able to hear me?
Yes,
Hello?
sir. Yes, sir.
Yes, sir. Yes, sir.
Yeah, there's some disturbance, that's why. Okay. Different kinds of IPRs. And IPRs and licensing technology agreements related thing we'll talk about.
Sadekar sir, unmute your device. You are muted. Sadekar sir, you are muted.
Yeah. Is it okay?
Yes, yes, audible.
So properties, all of us, we like to have some property, right? We have movable property, car, cash in bank, or furniture, or dress. Whatever, all our properties, which is a movable property. Immovable property is the land, building, which we are owning and all that, the immovable property. And now we are talking about intellectual property. So like, for example, literary works, inventions, innovations. So that is also the property. Many times we don't realize whatever work we do and produce out of that work, what really happens is the intellectual property. Many times we say, I must have, experience of this. What exactly that experience is all about? That experience is actually an intellectual property of ours, right? So this is very interesting to understand that part of it. So let us look at what are, like, very clearly movable and immovable property. We know about it. What comes under the, very slow, I think, huh? Hello. Slide changing taking place very slow. One minute. Huh? Professor, I'm not able to move the slide. Hello? Hello? Are you able to hear me? Hello? Hello?
Yes, sir.
Hello?
Yes, sir. Yes, sir.
Are you able to hear me?
Yes, yes, we can hear you.
But I'm not able to move the slide. Why slide is not going further?
Sir, just stop sharing and then again share.
Oh, okay. Stop sharing.
Stop sharing. Yes. Now again
Yeah.
share.
Yeah. Why this is happening? No, not at all.
Still not able to do?
No.
Sir, if any other files are open, please close those files.
Yeah, nothing is open.
Sir, we have given you authority. Your
Minute,
co-host, you can do.
Yeah, probably because of that is now. See, it's like this. Sorry for this.
No issue, sir. No issue.
Yeah. Okay. Now let us try. Yeah.
Yes.
Okay. Sorry for that confusion. Okay. So what is really an intellectual property includes? So intellectual property includes literally artistic and scientific works, performances of performing artists, phonograms, and broadcast. Even this comes under everything is intellectual property. Invention in all field of human endeavor. All inventions, what you do, those are the scientific or discoveries, industrial designs, trademarks, service marks, and commercial names and designations, protection against unfair competition, all other rights resulting from the intellectual activity to be included in the scientific, literary, and artistic fields. So everything comes under the intellectual property. So that one can say, whatever work I am performing is a part of the intellectual property of ours. Now, whatever protection each one will have can differ. It is not that same protection will be there for each one of this particular thing. Protection can be different. But everything what we do in terms of the intellectual use of development comes under the intellectual property. The intellectual property, now let us have a look at the intellectual property rights, very essentially recognized and accepted all over the world due to some very important reasons. Why really intellectual property rights people have accepted? What is the importance of that? First, to provide an incentive to individuals for new creations. It actually gives you impetus. It provides the impetus for development of the new creations. To accord due recognition to the creators and the inventors. Because finally, at the end of the day, recognition is also required for the people. So when I say, for example, I have taken a patent, or I have so many design registrations, it gives you the little different type of feeling. And that is also a very important thing. To ensure material reward for intellectual property. Now, like for example, I have developed some patents. And those patents are very, very, like there's a huge industrial use of those work which I have developed. Then I must get something materialistic reward for it. So the registration or the patent registration, etc., helps you for that purpose. And to make available genuine and original products. So what happens in the process of this, you also develop new products which have the features of a useful to the people as well as they are novel in nature. So let us look at the nature of the intellectual property, creation of the human mind. We talk about intangible property. It is not like I can directly put the value to it, right? Exclusive rights given by the states. There are statutory, for example, rights are provided by the government for this particular thing. See, just like your property of the house, you may not have the government protection for that. But for this property, there is a protection from the government. Statutory protections are there. Exclusive rights given by the statutory, attended with the limitations and exceptions. Always for anything there will be some exceptions, there will be some limitations. And these rights are not for the unlimited time. They are time bound. Depending upon the type of the intellectual property, they are time bound for each one of them. And territorial. That's very important. I may have the rights only in my country, or if required, I require to take the overall in different countries. I require to accordingly take those rights in the different countries. Because today's world, because of the lot of global regulations, it is possible to take the patents in the different countries or the IPRs in the different countries. So it has a territorial limitation and it has a time bound. Okay. Please tell me in between if I am too fast or too slow, or you are not able to hear, please let me know. Huh? So let us look, what are the things which comes under the intellectual property rights, right? Copyright and related rights. Copyright is one of the things. And what is the industrial property? What are things in the industrial property? Patents, industrial designs, trademarks, geographical indications, layout designs or topographies, integrated circuits, trade secrets, protection of new plant varieties. So these are the various things under industrial property one can have the rights, and copyright and related rights. Now what we are going to do, each one of these we'll see in detail little. But today, with time constraint, we are not going to discuss everything in detail. We'll talk a little more about patents. We'll talk about industrial designs, little bit about trademarks, and then we'll touch upon maybe geographical and trade secrets, little bit about that. Two things we'll talk about. Okay. So let us have a look at, now we said just now, every property must have a right. I have my car, I have my house. This means that every property has a right. Similarly, intellectual property will have the right. So intellectual property right. Now, what type of right? Just now we are talking about various things. Industrial, what are the things available right, and copyright. So if it is the idea which is in terms of the expression alone, there is no product, it's the expression, then it is a copyright. If I have an idea which has been converted, or an invention which is converted into innovation, and I have developed some product or process, then it's it can be patented. So it's a patent. Same idea, if it's a quality or the identity, that idea has actually tells me about my quality and identity of mine, then it's a trademark. That's the reason what you see, many companies are having their trademarks. Products have trademarks, right? The idea of a product, but only appearance of it, not is technology involved into it is not there. It's only based on the appearance it differentiates. That can have design registration. And in an idea, there are something maybe we cannot disclose to the people. Keep confidential, they are trade secrets. Like for example, Coca-Cola. The formula of the Coca-Cola is a trade secret, right? That's what it happens. Many of the products will have, there are trade secrets in every product, and they are not disclosed, but they are safeguarded by some means, right? So these are the various things. So this hello.
Hello, sir.
Yeah, what happened?
Nothing, sir. Everything is going fine.
I got disconnected.
Yes, sir. Please rejoin, sir.
Yeah, I'm doing that.
Share the screen,
doing
sir.
That.
Please share the screen.
Yes, I'm doing that. Just 1 minute. I don't know why it is happening today like this. Able to see? Hello?
Yes, sir. Yes, sir.
Are you able to?
Yeah.
Okay. So, yeah. So patent inventions, products, processes, material composition, technical solution to a technical problem, right? The artistic, what we talk about, that comes into existence immediately. Patent consists of invention, that anything, it can be product, process, material, anything of that type. Technical solution to a technical problem comes under the patents. Okay. And what is a trademark? A visual symbol such as a word, name, logo, label, monogram, slogan, etc. applied on an article of manufacture or service, indicate the origin of the goods and services. Industrial design, external features appealing to the eye. We are going to see each one of these in detail. I'm just giving you a little bit here. Industrial design is the external appearance, like what I said, new shape or the pattern or the configuration. And geographical indications identifies agricultural, natural, or manufactured goods originating from a definite territory in India, are possessing special quality or reputation based upon the unique characteristics of the geographical location. Like for example, Tirupati Laddu, or maybe something you can call mango from somewhere, Ratnagiri mango, you know, like that. So those type of things have geographical, or Kolhapuri chappals, right? So these are the geographical indications. We will not talk much about this because what really interests the academic people may be three things: copyright, patents, and industrial designs. So we'll talk a little bit more detail on these three aspects. Okay. Before that, I have given you a picture here which shows actually a product. On the same product, many of these rights can be taken. For example, we can take a patent because this product is, for example, it's something like it's a breath operated built-in dose counter. It is. Now this counter, for example, it will have technical content. It has function. It's an industrial use. So we can take the patent because it's a novel and inventive solution. Second thing, package and insert of that particular, the leaflets of that can have copyright. Then, for example, it can be have the trademark. I can write multi-healer TM or something like that, right? So that's possible. Then it can, then actually design, for example, appearance of it, how it looks. Based on that, I can do the design registration. And something confidential information of that particular thing can be a trade secret. So on a given product, all types of rights is possible to do it. Many people do that. Depending upon the type of the product, it's possible to do it. So same thing I'm explaining here. For example, like you look at that fan, and its fan is having same maybe lamp attached to it. Now that particular design can be an industrial design because it's the appearance of that particular fan. It can, technology of that fan, it may have different speed variation or something for which you might have done something special, can have patent on it. So Apple, for example, Apple symbol, that itself is a trademark, but the mobile can have the patent itself because it has a technology inside it, right? Coca-Cola, the title of the way in which Coca-Cola is written is a trademark of that, how it is there. Because it's looking, you can't use in the same font, same type of the things, you cannot use it. Now I shown something chappal there, and then like geographical indications. So this, it is possible for every product to have different rights depending upon content of it. Okay. Now let us, having seen what are the IPRs now understood, we understood. So let us get into little details about, little to know about. It's better to know what are the international organization and treaties in intellectual property. For example, there are two things. One is the World Trade Organization and World Intellectual Property Organization. It's called the WIPO. And World Trade Organization has a different thing, which are TRIPS, we will come to that. So there are various conventions. For example, Paris Convention for the Protection of Industrial Property in 1883, Bern's Convention of the Protection of Literary and Artistic Work 1986. Like that, there are various international union for new varieties of the plants 1961, 72, 78, 91. Convention of Biodiversity in 1992. And this is which is very, very governing at present, is the Agreement on Trade-Related Aspects of Intellectual Property. It's called the TRIPS, 1995. And international treaties are 1996. So let us see what is the TRIPS. TRIPS is the TRIPS trade-related aspects of intellectual property rights agreement came into being with the establishment of the WTO, World Trade Organization, effective from 1st January 1995. India is a signatory of TRIPS in the Uruguay Round Agreement of 1995. So we are also member of the TRIPS. That's very important because we are also governed by rules and regulations under the World Trade Organization, WTO, and it is governed by the TRIPS. So intellectual property rights itself is defined in the context of the TRIPS as right given to people over the creations of their minds. See, very interesting. Intellectual property word is what is intellectual property? Anything creation of their mind is the intellectual property. It's a very interesting word, and that is the definition given by the TRIPS. It usually gives the creator an exclusive right over the use of the creation for the certain period of time. That's what this is a definition. Why I showed this again, though we have discussed this, because it is also discussed, this definition has been defined under TRIPS. Then WIPO, World Intellectual Property Organization. They have UN organization dedicated to performing the use and protection of the work of the human spirit. Headquarters in Geneva. 184 nations as the member states, manages all IPs, training through academy and seminars. That's what they conduct. But more important is the TRIPS for us because we are governed by the WTO. Now, let us look at what is the scenario in India. Okay, in India, patent rights are governed by the Patent Act 1970. We should know about a little bit about this. That's why I written this. At present, third amendment of Act known as the Patent Amendment Act 2005 is in force. For applications of Patent Acts, rules are made by the government, which are known as the Patent Rules 2003. As of now, Patent Amendment Rules 2006 and further updated in 2015 are in force. Patent Act and rules updated in September 2015 are in force. For better understanding of the Act and rules, draft manual of patent practice and procedures, MRPP 2008, is made by the Patent Office. There are 4 patent offices in India having work distribution according to their geographical location: Kolkata, Delhi, Mumbai, and Chennai. So I just given you here the ministry of how these things are there. The Ministry of the Commerce and Industry, Department of Industrial Policy and Promotion. Under that, Controller General of the Patents, Design and Trademarks. So various things. For example, Patent and Design Office, there are in Kolkata, Delhi, Mumbai, Chennai. Trademarks also are done in all the 4. In addition, there is Ahmedabad there. Geographical Indications Registry is done only in Chennai. And patent information systems are there. So we can look at the Nagpur and this one. So these are the things available on the internet, but it's very important to know. Actually, I have not shown you details of the office addresses. They are available on the net. Okay. Now let us look at it. This is just the Indian scenario, which we had already talked. But what I have given in this slide is patents are governed by which rule in India. The design, for example, the Design Act 2000, trademark is by 1999, copyright by various things. Layout designs of integrated circuits, protection of undisclosed information by 1872. So these are the various things in India, rules which are applicable today. Now let us talk about each one of these little separately. I'm going a little fast because time constraint. So we have to finish by 12:30. So we'll talk about copyright, patent, and industrial design little in detail, and others will touch upon. Okay, and specifically I want to talk a little for startups. What is the licensing of the licensing of the patents? Okay, now let us talk copyright. So what is a copyright? Copyright is a legal term describing rights given to the creators of their literary and artistic work. Even a PPT prepared by you can have a copyright. The works covered by copyright includes literary works such as novels, poems, plays, reference works, newspapers and articles, computer programs and databases. They can also have copyrights. Films, musical compositions, dance and theatrical productions. Artistic works such as paintings, drawings, photographs and sculptures. Architecture, advertisements, maps, technical drawings and manuals. So if you might say, whenever you produce any drawing in your organization or in academia or anything, you prepare some manual, please write the copyright. So nobody should be able to copy the same thing for whatever you are developed. Actually, I don't know whether we write that, but some of things is that there are exemptions. Otherwise, your thesis, for example, can have copyright. But there are something like, because some government things, etc. Government think people can access it, but other people will have the little copyright. It's better to keep your presentations, etc. copyright. Copyright comes into existence as soon as the work is created and protects skill and labor employed by the creator in production of his work. So that's very important to write, but we require to mention there the copyright, right? Because it's not obvious to the people. People should know that there is a copyright. Actually the creator is conscious of whatever he has done and he wants to have the right for it. So formation of the pre-protection, voluntary registration. Registration need not be done. Generally, people don't do the copyright. Registration need not be done. Registration does not, as a matter of law, establish that what is registered is in fact and in law copyrightable subject matter. Okay, so that's why registration need not be done to my knowledge. Because you can even write it and it's okay. Duration of the copyright. Literally dramatic, musical and artistic works published during the lifetime of the author. Life plus 60 years. All other works 60 years from the date of publication. Okay. Works of government organizations, cinema, sound recording, photographs, etc. 60 years from the date of publication. So this is just to get an idea. So, specifically this becomes very, very important in terms of the dramas which people do, or something like, music which has been this one, somebody copying those tunes and all that type of thing. So this comes into that part. But you as a academia, whatever paper published by you, actually they are under copyright, because somebody cannot take directly that work and publish it for himself. That's a very important. So copyright is important from our point of view. Now let us look at the patent. So what is patent? A patent is an exclusive right granted for an invention, which is a product or a process that provides a new way of doing something or offers a new technical solution to problem. Look at this statement, a very nice one. A patent is an exclusive right granted for an invention, which is a product or process. It can be a product, it can be a process. Process means chemical process, for example, or some manufacturing process. It's possible to do that type of thing. Provides a new way of doing something. The important word is new way of doing something. It is not which is available today. It is something new and offers a new technical solution to problem. It should be a new technical solution to the problem. So these are the two things which are very, very important. We'll see which are the conditions, novelty, etc. We'll look at it maybe a little later. The limited monopoly right granted by the state enables an inventor to prohibit another person from manufacturing, using or selling the patented product or from using the patented process. This is without permission. This means if I patented, nobody can manufacture that product without my permission. That's very important. You cannot even sell the product without my permission. And this is what patent right comes. How many years, etc. We'll look at it. It is written there. Patents have territorial jurisdiction. That is, we have to register the patents in all countries where we have our interest. Like, for example, just to tell you, when I took the patent initially, my first patent was only in India. My second patent I took in 2 countries. My third patent, I took it in I think around 4 countries. So it depends upon where the interest lies. Because we were saying that this particular product is being sold in these countries, or it has an application there. It's better to protect that particular thing. That type of thing one can decide, and depends upon because everywhere when you want to register abroad, it costs money, right? If patent registration, etc. Taking a patent requires the money part of it, expenditure part of it. So depending upon use, like my first patent was taken. If you ask me, actually, when I took my first patent, I asked my that time our head of the department, because he suggested me that I should take the patent. So I asked him the question, sir, why we should take a patent? This product, because that's something what I developed was for the experimentation part of it, but it was novel. So he said, look here, I know we are not going to sell this product. However, the product you have developed is for some purpose, and that purpose is we are in the business of that purpose. So how people will know that you are trying to develop something and studying this little more for this particular purpose or this product. So it says developing the brand image is also sometimes a part of it, you know. Okay, and period of patent is 20 years. So invention in all fields of technology, whether products or processes, if they meet the criteria of novelty, non-obviousness, this is very important. We are going to define what each one of them means. Capable of industrial application. So look at this. It should have novelty, means invention not known to public to claim by inventor. So whatever, when you want to patent something, that particular product or the method or the process should not be there anywhere in the world, not only in the country. Suppose I want to take the patent in India. That doesn't mean that it's not available in India. It should not be available anywhere in the world. Patent while taking, so patent authority who gives you the grants the patent, they do the survey whether this is novel to that extent that it is not available anywhere in the world. Okay. Otherwise, what happens, it becomes like you are copying the thing and taking the patent. It's not possible, right? Then inventive state. Invention would not be obvious to a person with the ordinary skill in the net. Means something that should be a, you know, it should have some element of development. It must be having some element of the thought process which has gone into it. Something functionality has been developed from available functionality. So this type of thing, it should the inventive state which is okay, and that is non-obvious. It should not be obvious. I do this change and it happens. If that is the case, then it is not worth doing the patent. But it will also not fall under novelty. The second most important is industrial application. When I say industry, it is not only in the industry. This means it should be application. It must have application for the human growth. Invention can be made or used in any useful practical activity. That's important. Useful practical activity as a distinct from purely intellectual or aesthetic one. It's not only something looks good. No, it must have some usefulness. It must have practical activity as a distinct from purely intellectual. It's just not because, oh, I feel very happy about doing something. No, that is not the purpose. Purpose is it must have application for the human purpose, right? Growth. So that's how industrial application comes to. So these are the things which are important for a patent if you want to take patent anything. What cannot be patented? That's very important. What can be patented? What cannot be patented? So not fall within the provisions of section 3 and 4 of the Patent Act 1970. This is very important to know all of us. What cannot be patented? So there is a provisions of section 3 and 4. So let us look at what is the provisions of section 3 and 4. So under section 3, which says which are frivolous or obvious, something which is obvious cannot be. Now, I'm not going to give the examples of this particular thing. There will be available in the somewhere. If required, I can send it to the professor some details of this particular thing. But let us go through. We'll go through this list because this is a very important list. It is anything which is obvious. I have a product and I feel okay. I can small thing make a change and I can develop this. No, that is the obvious thing. Some small change can be done. So that is not doesn't become patentable. Contrary to well-established natural laws. That's a very, very important statement. There are natural laws. So something which is actually, you have done something which is actually proving the natural laws wrong. So it's the contrary cannot be taken because natural laws are very, very proven laws and hence it cannot go against it. And that's why a patent will not be granted. Injurious to public health. Anything, any product, if there is any small element of injury for then it cannot be patented. if it's the health or the environment or something like that, it is not possible to patent. So that's when we say I want to develop some process. In that process, it must have environment and the human safety as the inbuilt. Then only you can, because I cannot do something. It may have good application, but if it is injurious to the thing, then you cannot patent it. Mere arrangement or rearrangement. This is very important. By changing something, I suppose I am doing something, but I'll change the sequence of my manufacturing process. And I'll say, now it's my new process. No, not allowed. So mere arrangement or the rearrangement of that is not possible. Discovery of scientific principles. Scientific discovery of any scientific principle discovery is not patented. Okay. Discovery of living thing or non-living substances in nature. Suppose some material, and that material I do something, if I do the composition of that material change and something like that, it may be a different thing, but because the product wise. But otherwise, just because I'm changing the property of that particular product, it cannot be patented. That's why if you see many of the steels, etc., which are developed, they are not patented. But the steel for a particular application, that application can be patented. But you cannot, the steel modified is not patented. Okay. Method of agriculture or horticulture. That's another thing which is because that it has different connotations in the country, so it is not patentable. A mathematical or business method or a computer program. See, look here. Patent cannot be taken for the computer program. Patent cannot be taken for business methodologies. Patent, some mathematical inventions, you cannot take the patent. That doesn't mean you cannot have right. Some other rights can have. You can have copyright, or we want to see something else can be done for it. But patent cannot be taken. So each one of this, whenever you want to take something patent, just have a look at it, whether it is falling in any one of this list. So, and we have to make sure that it is not in this list so that we can apply for the patent. And most important is anything which is atomic energy related in this country, we cannot be patented. It's not only in the country, it's all across the world, not patentable. Because it has a safety related aspects, and that's why it is not patentable. Okay, it cannot be made obvious for the public because patents are available for the people to read, right? So this particular thing is not patentable. So I felt this is very important. That's why I spent some time on it. Okay. Now look at this. Patent application can be filed online in India by inventor, his assignee. Because, for example, when I was working in a company, I developed the say product, but though my name is to be there on an application, it is a patent is to be on the company's name. I was required to assign the patent to the company, okay, because the company's resources were used for it, and my all development was a part of the company's developmental work. So I was required to assign to this. So in a form, I used to sign at the back saying that I'm assigning this because the application is to go on a company's name, but inventor is to be my name. And then I used to sign that as saying that I'm assigning this project to the company, this patent to the company. Patents are granted by National Patent Office under publication and substantial examination of the applications. In India, provisions exist for a pre-grant and post-grant opposition by others. We'll come back to that. For example, now I'll explain you right now here. When you apply for the patent, what the patent is applied, then government actually publishes that patent. If anybody wants to take an objection to that patent, they are given some particular time, 6 months or 3 months or something like that. So people, if the objection comes, then we require to actually prove it, saying that this objection is not valid, or if it's valid, then patent will not be granted. Suppose you have copied something and you are applying for the patent, and somebody takes the objection saying that I have already product which is a similar thing to this, so patent should not be granted. So opposition comes, then you require to defend for that. They are valid within the now this is what we already talked about. And foreigners can also apply for patent. This means just like I can go and apply in the outside country, foreigners can also apply in our country. This I think will not get into detail of this particular thing, rights and obligations. But the important thing is exclusive right to make use of, sale or import the patented invention, exclude others from unauthorized use of the patent invention, grant licenses, assign rights to enter into agreements, and to sue others infringement, to surrender patent rights. Now look at this. You get all the rights, right? You can sell your patent or you can buy the patent, all that thing possible. But this means, just like I want to protect my rights, I have obligation also not to use others' patent for my development directly, because then I must do some change or something like that, but I cannot develop the other product. So in many of the companies, for example, people are very, more than you developing your IPR, you should also look into it. You are not violating the others' IPR. That's very important. All of us, like for example, if there's a copyright on thing, I should not copy somebody's thing if there's a copyright. Okay. Now the procedure for filing the return, filing the patent, filing of patent application prior to art research. Actually, when you want to file the patent, whatever work you have done, look at the various things, do the search, and find out whether something similar is available, not available, you know, then early publication. For example, there's you require to go through the patent attorneys. There are patent attorneys, like I'll not use the word agent, but those are the people expertise in writing the patents. Many of us, we start writing the patents. If you see the patent language, it's like a lawyer's language. So we should not attempt that. Specifically, when I took the patent, I can tell you, my patent attorney used to like me because he said, you are the only one who doesn't come, because from some of the people from my company before me, when I took the patent, there are very few patents in my company. So some of the reasons people come and they write the patent, I don't even understand what they are written. So I used to write very simply. For example, if I want to take a patent on something, I'll say, I want to take the patent on this particular product. I used to write what is the function of that product, what is available today. I used to write that, how that particular product is today, and what is the different in my product, and what advantages I get from that particular product, and if there are any limitations there, and what is the specific points which differs my product from the existing product, and what are the advantages. I used to write like a normal engineering report, and I used to go to the patent attorney and show him, say these are what it is. So he used to understand very quickly, and if I used to carry some product also to sometimes to him, or I used to call him and show him the product, all that I used to do. So writing for him, he used to tell me, saying that, oh, in your product, this is very important, very critical, we should claim it. Because, if you have seen all of you patent anytime, in patent, there's like a description of the product, a description of the process. It is numbered properly and given the thing. Too much technical need not be given, but sufficient information to understand what little bit nitty-gritty of that product should be given. You may not give the complete development, how it is there part, but functionality related things should be described in the patent. So it is written there. And most important part of the patent is the last part. All sketches, etc. will come. And last part is the claims. What is that you are claiming in that particular thing? What is the critical to the functionality of that particular product or the process? That is you claim, saying that this is my claim on this particular thing. And the claims are very, very important. Specifically, if you are studying the other's patent, then what is really required to go through is the claims. What is that has been claimed by the people? Because claims are written in such a way which is not sometimes obvious in the patent, but it can get into the IPR violation. That's the reason it's very important to study that. Okay, now let us come back to this part of it. Request for examination, grant, refusal. So these are various stages. You apply the patent, then examination occurs. There will be a patent attorney will apply, then patent office will check the thing. Examiner will be there, then examiner may ask you questions. And if everything goes well, they will give you grant the patent. Okay. And post grant the patent, they will be publishing in a gazette for any opposition of the particular thing, and then it will be given to you as a patent. If you really look at nowadays, there's the advantage. You can actually have provisional specification can be filed. Suppose you have some idea. you have done a preliminary work on that idea. So one can apply that, and within 12 months, you can final thing after you are developed completely, you can final specification can be filed after 12 months. Previously, it was not there. Previously, you require to have your product, but this has been done because sometimes the ideas gets leaked or something like that. In order to do that, this is the thing is done now. Okay. Then it is general description, technical, like we are discussed just now this, right? And the claims. The general timing, if you really look at it, it takes approximately 2 to 2.5 years. Filing the provisional specification 1 month, filing the complete specification 4 to 6 months or maybe 12 months, depending upon this one. Publication in the patent office after 18 months, they publish in this one. And patent office request examination 3 months. Then clarifying doubts raised by the patent office around 6 to 8 months. Opposition case-to-case basis, but it takes around 5 to 6 months. So total something like 2 to 2.5 years once you apply the patent, it takes roughly. Some nowadays it's a little faster also, I have been told, but my time it used to take around 2. But I can tell you in my all patents which I took, I got it very fast. I got it in 2 years time. Okay, 2 years, 3 months like that. So that was a fast process because patent office, the people who used to file the patent for me, they used to take less time because clarity used to come there. And we used to do a lot of survey literature, proper survey saying that this idea doesn't exist anywhere. And we got questionnaire from the examiner saying that he requires an explanation, you know. So how you write a patent is also very important. So let us go a little bit fast now. Industrial designs. So industrial design, like what I said, is the aesthetic aspect is the industrial design. That's the reason judged by solely by the eye, how it looks to my eye. You are not looking at the technical functionality of it. So ornamental or the aesthetic aspect of an article, aspect that gives spatial appearance and which differentiate the aesthetic visual form of a product. That is 3D or 2D features such as shape, surface, patterns, lines, colors, everything comes from the product. You know, that's how you might have seen. I'm going to show you some examples. Industrial designs are applied to products of industry and handicraft, technical and medical instruments, watches, jewelry, housewares, electrical appliances, luxury items, vehicles, architectural structures, textile designs. Like, for example, if you take a particular car, car's aesthetic from outside, inside engine, etc., all those patent, etc., different technical part of it. But how outside it looks can be how industrial design part of it. Does not protect any technical features of the article to which it is applied to. This means functionality is not the important. It's the aesthetic view of it. Design makes the product attractive and appealing to the consumer and adds to the commercial value of that for that reason. Exclusive right against unauthorized copy. Protection normally lasts for an initial 10 years, after which it can usually be renewed for the most cases up to 15 years. So first is the 10 years, after the 15 years. How to apply for that? No, now I'm just going to, okay, there's no, let me show this. Look at some of the products. Look at the shapes of this particular thing, you know, even a toothbrush, right? Aesthetic part of it. Functionality is a different story. It can be a technical part of it. How the brush, holding this, that, etc. But how it looks. So these are the various purse, for example, chappals, pharmaceutical products, tablet, for example. Some of the tablets have different colors. So how it looks inside formula is a part. It's the patented formula, right? Or it may be a trade secret. But the color of that tablet, how that this packing is done, all that can be under industrial design. Jewelry, for example, you know, specifically in the jewelry today, a lot of industrial designs are registered. Their registrations are there, you know. Okay. So, rights for the registration to the inventor are the, right? The proprietor or the proprietor of the registered design has the exclusive right to apply the design to any article in the class or without the design is in where the design is registered. this is a very important, specifically plays the role in the jewelry part of it, and textiles, etc. Period of protection is 10 years, extendable by 5 years. That's what we have seen. And what is not registrable is a design which is not new or original is not registrable. I think we can skip this part of it. Trademarks. Generally is the brand or the logo, all of you know. A visual symbol which may be word, signature, name, device, etc. Okay. So this all of you are aware. So trademarks is not that important to you. We can skip this and say registration of the trademark. So many of you might have seen the registered trademarks, no? Like for example, again what happened? Hello, I'm there. Hello.
Yes, sir. Yes, sir.
Yeah. I don't know why it is happening like this. Hello. It's not going further.
Hello, sir.
The slide again not moving.
Up to now, sir, again, can you rejoin, sir?
Yeah. Let me stop share and then check.
Yes, sir.
You want me to rejoin again?
Yes, sir. Yes, sir.
Yes, okay. Leave. Hello.
Yes, sir. Yes, sir. You are audible and visible, sir.
Okay, fine. Because I was unmuted. That's the reason it happened. Let me share now. Sorry for this. I don't know why it's happening today. Again, it's not going further.
उसको मिनिमाइज करके दिखाइए
Sir, can you minimize it and can you show, sir?
Which one?
That slide.
Yeah, minimize, is it? Escape karo? No, it's not. It's getting escape also. Yeah.
Yeah,
okay.
yeah, now it is moving, sir.
Now it's moving. Okay. We are only 10 minutes, right? Yeah.
Yes,
so
sir.
something will something will leave. Okay, trademarks we have seen just now. So this just which you know, Godrej, the way in which it is written, for example, Coca-Cola. So trademark, all of you are aware. GE, like looking at the Apple, those are the trade names and trademarks, right? Geographical indications we have talked about some time back. Alfonso mango and things like that. They are agricultural and natural products, which is not much relevant to academia as such, right? But just to, it may be better to know what exactly Darjeeling tea. There's a geographical indication. So anybody cannot say whatever the way in which it is taken right for it. Darjeeling tea has a different connotation, right? I written there Kolhapuri chappals and all that. Okay, trade secrets. We talk about some inventions, data, information cannot be protected by any of the available means of IPR. Such information is confidential as a trade secret. Like a formula for Coca-Cola is a trade secret, right? Or medicines, for example, some of the formulas of the medicines, they are trade secrets. So, but they have their rights, but they have different procedures. We need not worry too much about it, right? When invention is, when trade secrets are preferred, is when the invention is not patentable. But then I can do the trade secret because it cannot be patented. So you can take the trade secret for that. When cost of patent protection are prohibitive, it's too high. That's not really valid, really speaking. Okay, let us go to the how to guard the trade secret. We need not worry about too much about it. Now, IPR licensing. This is the what I want to cover a little bit because this is important for us. So, licensing is a permission granted by an IP owner to another person to use the IP on agreed terms and conditions while he continues to remain the ownership of the IP. Suppose I have taken a patent, but I can give the IP rights to somebody, but I am a owner of that IP on agreed terms. I may say that you give me so much money out of this or whatever it is. Sometimes many people develop the inventor and they say company will manufacture, and on a business of that particular thing, they will give something to it. So licensing, creation is the income source. Why this is important for startups is if they have developed some product and they are not going to develop that further and market, your product, you can give it to license to some of the companies and you can earn the money from it, right? It establishes a legal framework for transfer of technology. It's a legal thing. Technology to a wider group of researchers and engineers and creates market presence for the technology or trademark. So this is a very, very important thing from the startups which are developing the new product, etc. Suppose we are not going to sell that product. You want to go to the big companies after your development research has occurred, or the academia, you have developed some product and you want to go to anything, license the thing. There are many institutes I know which have licensed their products to the, like IIT, have licensed some of the products to the companies and all that type of thing. Okay. Licensing conditions. Owners of IP prefers to transfer the technology. That is your choice, whether you want to license the thing. Like all rights or limited rights can be licensed. How much? On what? He may not know everything about it, right? You say you manufacture like this, but you need not know the technology of it. But that depends upon how you negotiate. Can be exclusive or non-exclusive for sole. Okay. Most such agreements provide for royalty payment and non-transfer to a third party. If I have taken a patent or license from you, I cannot transfer to somebody else. You know, royalties can be upfront in the beginning, or it can be over a period of time, is a part of the product sale, etc. The particular uses for which the IP can be used are also generally specified. Need to be carefully about the competition law. Yeah. Is licensing profitable? Yes, it is a profitable. These are some of the numbers. We need not go through this. Validity of the IPR. Validity of the IPR, actually, as we have already talked, patent is 20 years, trademark lifelong, design is 15 years, 10 years plus 5 years, copyright 60 years. Okay, and geographical indication is for lifelong. Now, to end the thing, I have some thoughts here. The test of an innovation, after all, lies not in its novelty, the scientific content, or its cleverness. It lies in its success in the marketplace. This I like this quote very much. It's a Peter Drucker's quote. It says, important is whatever we have done, innovation, the important is what is actually success of that particular product in the marketplace. That determines how novel it is, right? Second thought is, innovation now is more of a relay race than a marathon. The baton of an idea might start at a university and move to the multiple companies before being commercialized. You can license to other people. Of course, batons can be dropped along the way. If something is not good, you can actually say, okay, this is not good, I'll do something else. Okay. So think away from the box. Every time when you do something, think over it, generate the ideas and own them IPR. So thank you for your patience. Thank you very much. I think I have covered overview for you. Thank you very much.
Thank you very much, sir, for your wonderful session. Now I request all the participants to ask your doubts or questions, if any. You can unmute your device and ask the questions or put your questions in the chat box.
How much time you have, Professor?
Sir, 5 to 10 minutes, sir.
Yeah, no, you wanted to finish at 12:30. That's why I asked you this.
Yes, sir. Yes, sir. Participants, if you have any question or doubts, please.
They can free to write to you, or they can send it to you, and then you can forward to me. Huh?
Yeah, that can be done, sir.
Yeah, but if any question, let the people ask. Another 3 minutes at least we have.
It is over to participants.
I think no question. Everybody is clear about it.
Thank you, sir, for holistically giving the answers to the, there is no questions. So we have shared the link for the feedback in the chat box. Please give your feedback for the session. Participants, please give your feedback to the session.
Okay.
Okay. Now I request Professor Ved Prakash, sir, to propose final vote of thanks for today's session. Over to you, sir.
Thank you, sir. I would like to express my vote of thanks to the speaker for enlightening us with his expert views and opinion. Sir has rightly pointed out some of the important key points about IPR. Sir, we are very thankful to you for making this webinar interesting and fruitful. I also wish to express my gratitude to President Dr. Zahir Kazi, sir, management team, Chairman, sir, Director, sir, for providing encouragement, support, and guidance for conducting such an event. We are also thankful to Controller CIRDPI Dr. Syed Imran, IIC Convenor Dr. Firoz Khan, IQSC Coordinator Dr. Mujib Tambuli. Also, last but not the least, thank you all the participants for your time and patience. Thank you all.
Thank you very much. It was my pleasure. Thank you very much.
Okay. So we will now conclude it, sir.
Okay, thank you.
Okay.
Thank you very much. I'm leaving, okay?
Okay,
Thank you very much.
Okay, sir.